Last but not least, Mr. Stickrod, come on up. 26 CR 167. Richard Stickrod is here out of custody for a pretrial readiness conference. Miss Velasquez, or Mr. Who's doing this one? Miss Velasquez is here for the people. So we have a jury trial scheduled next Tuesday, August 18th at 8:30 a.m. Miss Velasquez, are the people ready?
Yeah, the people would be announcing ready. I did just want to let the court know that we were having trouble getting the CV for one of the doctors who's endorsed and subbed. I just got an email this morning. It sounds like he was on vacation. He has just provided that CV.
Okay.
So that CV would be late, just given our discovery obligations. But I can provide that to Mr. Stickrod. If he can provide me maybe an email address or something, I can forward specifically the CV to him.
Okay. Mr. Stickrod, are you prepared to go to trial next Tuesday, August 18th at 8:30?
I will be if everybody can just prove to me like you are who you say you are, like proof that you're a government entity. Proof
No,
that you have
I'm not doing that. My question for you, sir,
delegation of authority.
I am not engaging in that type of conversation. My question for you is, are you ready for trial next Tuesday at 8:30? I've got about,
Is this on the record right now?
yeah. And I'll tell you just right now, I've got about, normally these pre-trials take about 5 to 10 minutes. I've got about 15 to address our issues. So we do need to make this somewhat efficient. My question again is, are you ready for trial on next Tuesday at 8:30?
I can be if provided with charters.
If what?
If provided with charters.
With charges?
Charters?
Charters?
Yeah.
Okay. So I'm going to take that as you are ready for trial. And Miss Velasquez, how long do we think this trial will be?
Yeah, I do think it will take the full week, so the 4 days that we're currently set for.
Okay.
I don't know how long it'll leave for deliberations for the jury. I think this could be maybe a more complicated issue for them to deliberate on.
Okay.
And so potentially they might be deliberating into the following week.
Okay.
What was that last part?
Deliberating into the following week.
Okay. And then I would also like to
Okay, hang on 1 second. Hold that thought, Mr. Stickrod, for 1 second. Okay, so 4 days with possible deliberations going into the next week.
Yes, Your Honor. I don't have an extensive amount of witnesses, so I do think that we'll be finishing somewhere around the time frame of Thursday afternoon.
Okay.
Worst case scenario, Friday morning.
Okay, go ahead, Mr. Stickrod, with your comment.
I would like to request a ADA advocate.
An ADA advocate, you would need to make that request through our administration office, which is on the 4th floor of the other side of the building. They handle all of our ADA requests.
Cool.
Yeah.
And how do I access the what is it, the Supreme Court of Appeals, or how do I appeal to them? Because
I can't give you legal advice on filing
there's
appeals.
there's a jurisdictional issue. Because it states that the Supreme Court has original jurisdiction of any case that involves the state.
Okay.
Then there's also one where it says, I'm the state anytime I use my signature, as far as UCC codes go, which
Okay.
that should work in every court case. So I'm
Okay, this is,
confused because I'm just studying law.
okay, that's fine, Mr. Stickrod, but this isn't about the court proving anything to anybody. It's about presiding over a criminal case where the people have the burden of proving whether you are guilty or not guilty.
Jurisdiction still has to be established.
The court does have jurisdiction. This is a crime that allegedly occurred in El Paso County.
Can't determine that.
So I'm not going to,
The court can't determine its own jurisdiction.
I'm not going to argue with you about this. This is a pretrial readiness conference. And I'm not engaging in a conversation about charters and the UCC and all of that. So we're just determining whether we are ready to go to trial. If you want to do your own independent research on that, you are welcome to do that.
For the record, this is a due process violation.
Okay. We have 4 days for trial. And, okay, so when we select our jury, you will be striking from the presumptive panel. Mr. Stickrod, this is the presumptive panel, so the box is the presumptive panel, meaning that any strike that you exercise will have to be from the box, and then as people get struck, we fill in the empty seats from the people in the back.
What if I remove all planes and boxes?
What?
Remove all planes and boxes, so it's a even playing field?
I don't know what that means.
Then assign you as my fiduciary
Okay, this guy ripping off all parts of the script.
You're not
for
gonna
the
do
public
that.
trust
Okay. That's not
or whatever. Set
happening.
a key.
And,
Either way, jurisdiction has to be established before we move forward.
okay, I'm comfortable with the court's jurisdiction. So in my mind, it has been established.
I still don't have your bond. I have your oath. Do you swear by your oath right now?
Sir, I'm not answering these questions. I'm the one in charge of controlling the pretrial
For
readiness.
the
So,
record, will not swear on her own oath.
okay.
Just saying.
We're going to have one alternate juror, and Mr. Stickrod, do you have, other than your jurisdictional challenge, do you have any evidentiary issues that you want to discuss today for trial?
I still haven't received any body cam footage. Anything that my lawyer had, I've been over there twice.
Okay.
He hasn't answered back, so.
Okay, well, that's certainly a concern because you're saying that you're ready for trial, but you haven't reviewed any of the discovery. So are you sure that you're ready? And it's fine if you still are, but usually folks have reviewed the discovery, so you know how to prepare your cross-examination and put on your evidence and stuff.
Well, my thing is the affidavit that's filed, Vanderpool, I think
Mhm.
his name was. His testimony completely went opposite of what she was saying. And then half that's hearsay, so I'd like to strike down that affidavit and the eyewitness testimony of the officer.
Those would be the types of things that you would raise at trial. I don't just decide in advance unless, especially if it's just that you don't think that the person is testifying consistently with their affidavit, that is impeachment or cross-examination. But my question for you is, not having the body cam and the discovery, do you believe that you are ready to go to trial next week? And if you say yes, that's fine. I'm not suggesting you should answer a certain way. But that could potentially hamstring you in how you prepare the case if you don't have the discovery. And I can order the people to provide you with the discovery this week. So you have it if you don't have it. But you tell me, do you think you're still ready for trial next week?
I mainly wanted my transcripts, but they're trying to charge me a down payment of $450 for them.
Okay, that's not an answer to my question. Do you?
That would make me ready if I had my transcripts, which is also why I wanted the 88. And I figured you'd be able to speed it up if I did it in person here than if I filed the motion through paperwork process.
Do you think you could speak more into the microphone? For some reason, I'm having a little trouble hearing you.
I feel like saying my verbal motion here can make it like grease the wheels to make it move faster for the ADA and all that.
Yeah, the ADA stuff just goes through the ADA people in our admin. They handle all of that.
Okay.
So you could do that
Do they
today.
have y'all's bonds up there too?
No.
Where's that located at?
Sir, I'm not answering these types of questions, okay?
No, it's part of jurisdiction. Like it goes to the oath like peanut butter and jelly. You know, you can't have one without the other.
Okay, they're bringing food into the script now? Next is going to be Pringles. You can't eat just one?
It doesn't
Okay.
count.
My question for you, and then we're going to move on, and I'm going to take it as you answering ready if you're not giving me a direct answer. Are you ready for trial next week?
I don't understand. I don't consent. I don't contract.
So you're not ready? Are you
Understand.
asking for a continuance?
Until jurisdiction's established, I don't understand.
He's a little bit too comfortable. He needs to be shut down.
Okay. Okay, you're not answering my question. So you did answer ready earlier. I've asked, given that you don't have the discovery, if you're ready, and you're not giving me a direct answer. So I will find that both sides are ready. Do you,
I think this whole thing should be void and vacated because
we're going to print off for you the court's trial management order that was filed May 4th of 2026. So that governs other pretrial exchanges that will need to happen before the trial. So if you have proposed jury instructions, things like that, make sure that those are being filed according to my trial management order. Given that this is an F3, I will give each side 40 minutes for voir dire. That is just the amount of time that you will have to question prospective jurors. So 40 minutes for voir dire, that is in the panel or in the trial management order. We've talked about the jury selection, one alternate. Ms. Velasquez, do you have any objection to live streaming?
I have no objection to the live stream, Your Honor.
Okay. Mr. Stickrod, do you have any objection to the court live streaming the trial?
I'm still stuck on jurisdiction.
Okay. Do you have any objection to live streaming?
Are you saying we're not going to establish jurisdiction at this time?
I'm asking you for the third time if you have any objection to live streaming the trial.
I object to moving forward without jurisdiction.
Okay, that's a non-responsive answer. So I will live stream. Please advise your witnesses that sequestration does include live streaming and WebEx.
For the record, nobody has given me any proof of authority
Okay.
whatsoever. What up? To me, y'all are just random people that showed up at my doorstep and took my kids. I need somebody that has a red seal, District 3 court. Is this common law? Is it maritime? Because those are the only two criminal jurisdictions, unless this is my civil case. So, I mean, I just want to know, what are we working with here? Because I didn't commit a crime on the high seas. I mean, jurisdiction isn't just where you did it.
Okay, I disagree with what you're saying.
They haven't even
And
said
I'm
the
not-
cause and nature of it yet.
I'm not requiring the people, the jurisdiction is established by Colorado law, and I'm not engaging in any further
Colorado law does
conversation on
not
that.
supersede the Constitution.
Okay. And sir, if you want to do your own additional research on that to convince yourself that we do or don't have jurisdiction, you're
I'll go
welcome
on
to do
45
that.
minute rant about it.
And I'd ask that you not speak over me. Okay, so
Mhm.
I think I've covered everything that we need to do for the pre-trial readiness conference. Just make sure for the people and for the defense that you are complying with the trial management order in terms of deadlines for filing things. Ms. Velasquez, is there anything else for the people at this time?
No, Your Honor, thank you.
Okay, Mr. Stickrod, anything else?
What are deadlines?
They're in the trial management order.
Is there anything that I missed because I had a lawyer here, and what motions did he file? Because I haven't heard of any.
You're gonna have to look in the court file since you're representing yourself. You can't rely on me to give you legal advice or things like that. We talked about that, but I don't believe that your lawyer had filed any motions. Okay, all right.
Because of my, sorry, I'm a little agitated even before I came up here, my bad. There has to be some way, because I've gone to get compensated for my time of doing the lawyer stuff, because I'm about to lose everything. And the way my courts are set up, I can't work. I've got two different cases going on right now. Both of them are going to be jury trials. I've been out of work for 6 months because they make us, well, I got fired when I got arrested without a warrant.
What is your request?
Some form of compensation.
Denied.
To pay my bills.
Denied. Denied. Okay, so you may visit the fourth floor of the other side of the building if you are requesting some sort of ADA advocate or accommodation. They can help you with that. Otherwise, we will see you back here August 18th at 8:30 for your jury trial. That will be the day that we will be going to trial.
What about my counterclaims? Did you file any of those?
No counterclaims are filed in this case, and it's not a case where counterclaims would be filed. All right, you are released. Thank you. 26 CR 167, Richard Stickrod appears in custody, representing himself. We have Ms. Velasquez here for the people. We're set for an appearance on an arrest warrant due to Mr. Stickrod leaving the courthouse last week when we were getting the jury up to the courtroom to begin his trial.
Objection, but I would also like to state something.
Okay, hang on one second to that. Let me just ask Mr. Stickrod, are you still wishing to represent yourself? We've already gone over that, but I do just want to make sure. Is that your decision?
I believe so.
Okay.
Need us, call us, please.
Hmm.
If you need us, call us, okay? We can come on your case.
Can I talk to somebody? I haven't been able to talk to no counsel or nothing.
Eh?
Well,
And what I've read is you're supposed to be my counsel when counsel isn't
no,
afforded to me.
I am absolutely cannot be your
That's what the
counsel.
Constitution states.
It does not say that, sir, and I cannot be an
And
attorney
if I have my
for you.
paperwork, I can guarantee it. I can read you the section, the article and everything.
Okay,
Just like I'm considered we the people of the state of Colorado, and I would motion to dismiss it also.
Okay.
okay.
And I have the proof of that also.
Okay, Mr. Stickrod, we do need to reset your trial. Okay, and then, so let's get that date set, and then I know you said you wanted to make a statement, so
Wanted
you
to
can,
apologize for the way I acted that day when you got up and left. I thought from everything, that was a Hail Mary because you're saying 10 to 32 mandatory, and nobody's given me any offers for anything, and I don't see that as a viable remedy for my kids and my wife, and to lose my house, to lose my family, to lose my everything. And my mom, she's taking care of my son right now. And my grandma, she's got dementia and she's in palliative care. And I'm trying to get the fast track to help them out. So if there's like probation or something that I could do, or like a deferred sentence, I can show you that I'll be the greatest, whatever Star Spangled Banner, whoever you need me to be. But my son is my main priority. And so when you say 10 to 32 years mandatory for something that I passed every health and wellness check, all 8 of them,
okay, hang on.
for
Mr. Stickrod, I'm interrupting you simply because you have the right to remain silent, sir. We've already
Oh.
gone over this. Everything you're saying is being recorded. I can't give you a deal. That's not something I have the authority to do. You can try to negotiate with the prosecution, but you can't do that right now in the courtroom. That's something that happens offline.
they won't even talk to me.
I'm sorry, we can't have little ones in the courtroom. We do have court care downstairs, so you can use that, but we can't have children in the courtroom. Okay? Thank you.
Can the prosecutor even talk to me? Because they haven't even said anything to me.
I guess not, because previously he was running the full Sov-Cit script.
They can. I don't know if they're willing to have a conversation with you or not, but
Just for the record, Your Honor, when he became a pro se, I provided him my card and I told him if there was any plea negotiations he wanted to discuss, that he could use that card obviously to email me or call me. And Mr. Stickrod did not use that opportunity.
I no longer have that card. I figured somebody would call me.
all
And
right.
nobody called me or emailed me.
So first things first, we do need to reset your trial and then we can talk further, but the court did find a waiver of speedy trial due to Mr. Stickrod leaving the courtroom and the courthouse. So the new speedy date is February 24th, and we'll get the trial scheduled. Let me see here, August, October. We're gonna have to do,
Can I post bond or can I be released back onto my original bond?
Hang on let me get this
Yes.
date set before we get anything else going, okay? So I think we're gonna have to do November 3rd at 8:30. And then a pretrial conference will be October 26th at 10. So November 3rd at 8:30 for trial, October 26th at 10. Mr. Tiplitz, could I impose on you to write those dates down for Mr. Stickrod?
I sure can.
Thank you. Okay, so Mr. Stickrod, let's talk about this. Miss Velasquez, any answer you give is fine, but just for his clarification, are negotiations over at this point or not something you'd be willing to do? Again, just for Mr. Stickrod's information.
I'd be willing to negotiate, Your Honor. Obviously, that just entails a reasonable conversation. If that goes beyond that, then I may reconsider.
Okay, and do you have a card that he can contact you?
Yes, Your Honor, I can provide him.
Okay, so Mr. Stickrod, she's gonna give you her business card. You can contact her at that if you,
Try readiness.
Thank you.
Call me
If-
if you need a lawyer.
Thank you.
if you want to have a negotiation conference or conversation with her. As she mentioned, it's gotta be strictly, limited to that.
Do you have any do you have any negotiations right now?
We can't do that right now in the courtroom, okay?
Yes, ma'am.
You're not obligated to reach a plea. She's not obligated to continue negotiations, if she doesn't think they're fruitful. So that's something that happens between the two of you outside of the courtroom. We have your trial scheduled, and right now you're indicating that you, want to represent yourself. Okay, so you brought up bond. Are you asking the court to set a bond?
I was already out on bond. I was wondering if I could just continue with that bond. You already know I'm not gonna run or anything. I don't run from anything. I
Okay.
will always be here.
He'll always be there. She keeps him in custody.
Okay, I mean, you literally ran, you
What-
left the court.
Well, you left the courtroom first, and so I was just acting on that from what I saw. And when you hit me with 10 to 32, I'm trying all Hail Marys I can, you already know, to try to beat the case.
Okay, so
But I
I
never
left
not show up.
I left the courtroom to go back to my office to wait for the jury. You
I didn't.
left the courthouse. Where, you thought what, I left the whole courthouse?
So
Just
I
went
walked
home?
around for an hour with your security that was here. And I went down to the clerk's office, got paperwork filed, I got paperwork printed out for me. And
Okay.
all that. I was waiting with security because if they wanted me to come back, then I would have. But I was there for like 45 minutes walking around with security.
Okay, let me add, so I can't reinstate your bond without consent from your surety, which I don't have in your file, but assuming you were able to get that, Miss Velasquez, what are your thoughts on reinstating bond?
Your Honor, I have an objection to reinstating bond. I do believe he's entitled to bond at this point. My request would be that the court at least double the bond that's currently set, which I believe was at 10,000. So my request would be 20,000, potentially cash only, given the fact that we were just waiting on a jury and Mr. Stickrod left the courthouse.
Okay, sir, what would you like to say, if anything, on that bond?
I didn't run. I just thought I did what I was supposed to do was to, because you never explained on your way out. You just kind of said, I think, off record and walked away. And from everything that I've seen, that would be considered abandoned ship. But I'm guessing that's not a real term. That was just a Hail Mary I was throwing. But I waited around for about 30 to 45 minutes walking around with the security officers that you had posted at the back doors when I was here.
And you didn't come back up to the courtroom?
When I went down to the clerk's office and I was waiting for if anybody was saying anything over the radio. And the guy was like, well, I think you're free to go because there's nobody saying anything there's no radio chatter. Which normally if somebody would run out of the courtroom, there'd probably be radio chatter about it.
Okay,
So but
And
I
what do
waited.
you-
I promise you, I waited. You can look at the security footage.
what do you mean when you say it was a Hail Mary? What was a Hail Mary?
Well, I saw that when a judge left the courtroom that it's considered abandoned ship without an explanation.
Where did you see that?
It was on YouTube, I think, at the time, because I just study everything I can get my hands on because I have nothing better to do but study law. And then when I was looking it up, it was canon law. Is it canon law?
Okay.
Or I read American jurisprudence, and it was canon law. I think it was under canon law that if the judge leaves without explanation, that it's considered abandoning ship, and that me as a living man, since they're considered an entity, I'm the only one that could take helm of the ship or something like that.
We're not on a ship.
Oh, it's
sir.
considered a dry dock because
Okay.
there's a yellow fringe around that flag.
Okay, we're not on a
Says
ship and
Maritime.
we don't apply maritime law in this courtroom.
So it's common law because there's only two jurisdictions that can be applied to the case.
I'm not, we've had this conversation before and I'm not going to argue with you about it. I've explained what type of law applies and
Article 3, Section 1 of the
I'm
Constitution is very
not sure
clear.
if it's not sinking in or if you're just not willing to accept
Well,
it.
no,
But,
Article 3, Section 1 of the Constitution is very clear.
sir, I have a
That's the
courtroom
law.
full of people and I'd like to finish up with your case. So I am going to set bond in the amount of $20,000 cash only. The reason for that is that last week, we were set for Mr. Stickrod's trial. And the court had reset a different case because, Mr. Stickrod's trial was going. We had 65 jurors or so on the way up to the courthouse. Mr. Stickrod left the courtroom and then ultimately left the courthouse. I don't find credible his argument today that I somehow made it okay for him to leave because I abandoned ship by going back to my office in the back hall to wait for our jurors, which I made clear that that was what we were doing. I explained what would.
No, you didn't
happen
explain
when the
anything. You
jurors
just left.
came up to the courtroom, that we would engage in voir dire and select a jury.
So
and start
objection.
The trial. And so that will be the court's order
That's perfect.
regarding bond. We do have the
Mike.
trial rescheduled and we will see you
I would
at the
also like
next
to
court
appeal
date.
to a federal court for this,
Thank
or
you.
appellate court to look at this.
Set. Thank you.